Hello and welcome to the Taking Liberties after show. This is our first after show for the year, and it's just because this topic had us ranting and raving for so long with each other during the pre-show where we were discussing which topics that we decided to do a whole after show dedicated to this. So you're about to
We should call it
listen.
the after rant.
It's not really rant though. It's just three people discussing
Yeah.
about one topic rather than a group of topics. Anyway, so what you're about to hear is basically a science student, an engineer, and Tim, I can't remember what you did.
I'm in accounting.
Yeah, so and an accountant. So three people who are explicitly not lawyers talk about basically something that was Antonin Scalia's topic, which was constitutional interpretation. So
Got my
if you're a lawyer, just listen and note down all the mistakes and everything that we say, and then post it in the comments section for this video or like on our Facebook, because we'd love to hear back, where we've gone wrong or how little we've understood something or how well we've understood something. But sorry, to get to the premise of this entire sort of little after show, Antonin Scalia basically died over the weekend, and Antonin Scalia was a quite notable, probably the most notable Supreme Court justice who perpetuated the idea of originalism or original intent, or the author's original intent for being the basis of the basis of interpretation of the Constitution in his decision making. He wasn't, of course, very consistent with this. There are well-known examples, and we'll talk about them. But the contention that we had, like Dom and I basically started this, was that he's not really much of an originalist as he is more of a textualist. And to get an understanding of those terms, textualism is where you're looking for a textual. Actually, Dom, you probably have a better
yeah.
explanation of
So
textualism.
yeah, the textual evidence is the textual is interpretation is just basically looking at what the actual text says and what an ordinary person would understand that to mean. Not necessarily in at the time of the writing of the document or anything like that. Just what is there, and you don't try and read in like the spirit of the law or try and interpret the things as a living document because it has a process for amending it if it needs amending. Um, so yeah, it's
Now,
yeah, you
so from my perspective, I would argue that original intent is actually a type of textualism, in the sense that it takes that takes that text and tries to attribute the intent, instead of being from the layman, or rather, how an ordinary person would try and perceive it, as the text from what the author intended it. So they're not vastly different. It's just what your
but
perspective is on how
but
it's meant to be interpreted.
yeah, but
Uh,
the textualism approach takes more of a death of the author kind of mind to it,
yeah.
in that what's there is there. It doesn't matter what they were thinking when they wrote it, just what they
It's
would.
very narrow.
Well, yeah, yeah.
Well, yes, of course. The law is a specific thing, though. It should be narrow.
Mm.
So from my base, so one of the things that they say about Scalia, this basically started because I pointed out that original intent is actually a form of judicial activism, because you can't interpret the thoughts or the opinions of someone 200 years after the fact without like interpreting your own opinion into it. Which is what Scalia has done several times. So the best example I can think of is with the strike down of Section 3 of the Defense of Marriage Act. Now, the Defense of Marriage Act was a horrible, horrible act, which any American will point you doesn't make any fucking sense and should have been struck down on its complete like. So the Defense of Marriage Act basically says that no state can no sorry the sorry that no state.
Federal government cannot recognize any same-sex marriages, even in states where they're legal.
Yeah, correct. So there's that entire concept, and there's also something in there about forcing other states to accept gay marriage, which didn't make sense to anyone, which is what Section 3 basically said in obviously a more legalese sense. Um, But yeah, basically, Section 3 was this horrible abomination which effectively made de facto and common law same-sex marriages illegal. Um, Utterly retarded, right? And it was right to be struck down. Now, Antonin Scalia basically dissented against that, saying, like, there is no constitution. So, dissented against that, saying, like, it was a majority decision passed by people in the land, passed by duly elected Congresses, right? Therefore, it should stand. There's no constitutional basis for marriage because the authors didn't intend it. And I'm sitting there going, like, well, hang on, that actually doesn't make that law valid. That actually invalidates that law because you're saying that the authors never intended federal governments to have laws about what states did and didn't do with marriage, right? And clearly, this is an example of a law that is quite making certain types of marriage illegal. So, at least with the original intent on that case, he's interpreted his own sort of way into it. Similarly, when it comes to Citizens United, he envisioned this entire concept that the original framers would have realized that there would be technology like the internet coming around. And therefore, like I agree with him on Citizens United. I just don't agree how he got there.
No,
Uh,
from what he said later with his textualist approach is that it's not that he would have foreseen that. It's what does free speech mean currently? What does the ordinary person understand?
which is
The
how I would have gone with it. Yeah.
yeah. I'm not sure if that's what his.
No.
This is how I've heard him describe it in a video. So I'm not sure if his actual his concurrent opinion was different, but like what we understand respecting an establishment of religion or prohibiting the free exercise of or abridging the freedom of speech or the press or the right of the people to peaceably assemble and to petition the government for redress of grievances. There's nothing in there that
Speaks to original intent. Yeah.
yeah, that like there's a very easy way to interpret that from a purely textual basis that includes everything on the internet, on all of that, that strikes down all the provisions about hate
Agreed.
speech. There's nothing there
Agreed.
about hate speech or of it not being valid for electronic
Agreed. Agreed.
typewriters.
Yeah. Yeah. So, from that basis, like, I agree with him that you can't have this notion of a living constitution. I agreed with his statement that the constitution is essentially dead. It was dead the moment they wrote it down. This is what it says. Um, However, like I said, original intent is not the way you arrive at that conclusion. A purely textualist approach is how you get there.
Mm.
So, I mean, if that was what I was aiming for, I'd aim to be a textualist.
Yeah, and
Um,
that's what I argue that all of his good decisions were based on textualist reasoning. The ones
yeah,
that were original intent are was he around for no, he was just after Roe v. Wade.
yeah, he was
Um,
after. Yeah,
yeah, but all
yeah,
of the subsequent cases where he has, I think it comes down to it. He goes for the original intent and interprets his own intent. Just basically inserts himself as one of the founders. Founders obviously must think like me because I'm a smart guy and they were smart guys,
yeah.
and
So
comes
yeah,
along.
you don't accept that he's right about what he thinks about the founders?
Well,
No, you might have been right about a subset of founders. The founders were just as, opinion diverse as we were.
Mm.
Sorry, as we are. Look, I think a large part of this problem is because the United States doesn't have a clear way or a clear guide, something like the Acts Interpretation Act, that tells you exactly how to interpret an act. So, like, for example, in Australia, we go by the words of the actual statute, followed by any explanatory material, um, followed by the actual explanatory memorandum. And then you've got like the actual Acts Interpretation Act, which has the definition of certain words and how they should be interpreted. And then finally, like as a last port of call, we've got the second reading speeches that we can sort of go to. Like that is the process our judges go through to get there. Having said that, though, our judges are largely judicial activists, but the way they arrive at their reasoning tends to be largely textual reasoning, which is actually really bad. If like, which is not not really bad. It's actually good if you're of that framework that Antonin Scalia followed. It's really good if you believe in the law as a very technical thing. Um, but it's not bad if you're like a libertarian who's hoping for cases like From the Castle, where they go, it's the vibe of the thing, and basically acknowledge some basic property rights, right?
The thing is, the Constitution needs to protect those things in the first place. If it doesn't, then no amount of interpretation is going to strike down a bad law.
Correct, correct. And unfortunately, our Constitution wasn't written in that way. But
The US one was pretty much, but just left so many holes open for creeping in with this exact sort of, you know, living document style things, and a few amendments, but
yeah,
mainly the Commerce Clause.
yeah, I think the Commerce Clause needed to be better
General-
worded. It can't possibly mean what the living document type people basically say it means, because if it does, it's just an excuse for the federal government to take over everything. And in that case, why the hell bother with the 10th Amendment?
Are you aware of what's the case called? The wheat burning case. You aren't.
Oh, I heard about this. Was this like it was one of the examples of like tariffs, wasn't it? It was like
No, no.
not tariff, but like a
It was. I'll look it up. It basically meant that you couldn't grow. No, you had to not grow wheat.
Yeah, I think I remember this
I think it
case,
was-
and he grew some extra wheat for himself, didn't he? And then he consumed it, and that was still counted
Yes,
as interstate
and that-
commerce.
yeah, affected the interstate commerce. It was.
Yeah.
No. He didn't grow wheat, and his right to not grow wheat was the thing that they were talking about. He didn't meet the quota. What Wickwood versus Filburn? Yeah, it was.
This sounds like the Tony Giolatti case as well. The Potato Marketing Corporation.
I'm listening to you two guys debate this originalism versus textualism, and I don't see too much reason to debate. I mean, textualism is what the words say, but originalism is when you go back to what you think they meant.
Yeah.
How are they different?
They're different in that you're interpreting what the people who wrote them would have meant versus what the words
Actually
mean
say.
actually say. So you could say, with the right of the people to keep and bear arms shall not be infringed because a well-regulated militia being necessary to the security of a free state. That means,
They didn't. Yeah, they didn't have assault rifles back in there, so they were only talking about muskets, right? You could interpret it to mean that if you really wanted to.
Alternatively, you could say, well, this must mean that private citizens are allowed to own nuclear weapons because they need to be of a malicious standard that's to defend the free state.
Which is
but I think that the constitutions always have to be interpreted with current technology. So you're saying that that's a textualist approach?
Yeah.
Yes, the textualist approach would say as the layperson would read it today, rather than what
so there would be an originalist argument against assault rifles, is what you're saying.
Yes, there would. There would definitely be an originalist argument. In fact, a lot of very liberal lawyers have argued that the Second Amendment means, muskets, not assault rifles, and that's
so you can't base you don't think you can base your opinion on originalist arguments and still be a textualist?
You're still arguing for the actual meaning of the words. Like you're still coming down on what the words mean, as opposed to guiding principles, which is the difference between a judicial activist and a textualist. But like the debate is really, what are you basing your textual interpretation on? And I personally think textualism is better because it's more semantic, which is better when it comes to the law.
It means that, yeah, people set out knowing what the law is quite clearly. You can, expect to keep and bear arms and not be arrested and thrown in jail. You can speak freely without being arrested for hate speech. You know,
So you don't think so you don't think it's valid to go back and say what the founders intended when they put all these
I'm
put all these
actually no. I'm
amendments.
listen. I'm fine with people doing that. I would class that as judicial activism, a type of conservative judicial activism. It is
Because
yeah,
you're claiming you're claiming your opinion is what the founders are.
exactly because there's no way you
So,
can.
so
There's no way you can possibly verify that.
well,
Is what was what I would
the,
say.
the thing is, you look at what they said during the conventions about they weren't even going to put a Second Amendment in because they thought, what government would possibly ban guns? We need guns. We use them all the
And
time. We
yeah,
just fought off the British.
And Madison and Jefferson were crucial for the victory of that to get in that Second Amendment. People don't. Yes, people like we know in the Federalist Papers. You had
But,
Hamilton basically arguing, like just asking, "What the hell's going on? Why would a government get rid of guns?"
but
And
the
people
thing
had to
is,
point out, "Yeah, sorry,
why Hamilton argued that was because he saw that, well, in the future you could have these sort of living document type people or even original intent people coming back and saying, well, the government put that in there, so obviously that means there must be some sort of power that the government has to regulate guns. No, even though it says it's banned completely, that must mean they would have thought that, oh, the government could regulate guns, so we just need to tinker a bit and get it through a court.
yeah,
That's what he
precisely."
wrote in 38.
Yeah, I can't remember which Federalist paper it was, but yeah, like there was a big discussion around this. The entire Bill of Rights basically came down with a whole bunch of Congress, like the first congressman, basically sitting down and going like, "Oh, we've actually left massive loopholes in how much power like the state has, how much power the federal government actually has," and they were like, "There's things that it could do, and we need to limit some of these things."
Well, they've only got all that Congress can do is contained in Article 1,
Hmm.
and that's they've completely overstepped that bound there. Just no state shall enter into any treaty. But yeah, they uh, which one? Um, yeah,
The
the
which one?
oh yeah, the to raise and support armies, but no appropriation of money that's used shall be longer for a term of 2 years to provide and maintain a navy. Uh, uh, so yeah, you can't have an army standing longer than 2 years.
Yeah.
Uh, Provide a navy. Make rules for the regulation of naval forces. Oh, you can't. The only thing you can do in terms of suppressing insurrections and repelling invasions is um, to sorry the militia, right? You have to ask them to go to war. The private militia, you can't order them to go.
Yeah,
Like,
so there's a lot of things that the US doesn't do now that the Constitution said that they should. But that's not the point, right? We're talking here about how things like original intent. So yes, the way original intent works, it doesn't necessarily mean what Scalia meant, right? Is like yes, you can do original intent, but original intent can also argue the other way, right? Which is like I said, some
Well, the
liberal.
whole idea of original intent is to resolve dispute. You're saying it doesn't resolve anything.
No, I'm saying it's problematic. It creates more potential issues for activists. Sorry, it creates more
so
activism rather than less.
also you can't use the Federalist Papers as any sort of thing on your decision. It's just because they're not part of any of the legal documents. You can't
Yes.
use them as any basis for it because then you can't determine original intent. That's not unless the
Well,
Federalists were
I,
introduced evidence.
I'm not entirely convinced of that because, like I said, the way we interpret our laws, we go to the second reading, right? I would say that the Federalist Papers would represent something slightly lower than that. Say, like, press releases, right? You can definitely use press releases. I mean, barring that you have the absence of everything above that to see
The,
what the minister meant. Like, if it was something on a very, very technical issue, like say, like the metadata bill, for example. And I say this because this is actually a really good example of this. How like the minister was asked, how much money will be forked over to the telecommunications companies to basically, you know, um, to basically uh, compensate them for the entire package that they're doing. Now, that's not written down in the legislation. That's basically something that someone in finance will basically, write down and squirrel away the money for in Treasury to pay these companies back. Now, if the minister says, like, oh, we'll pay them back everything, right? That's effectively the minister at a press conference has written a blank check to those telco companies to effectively get all this money back. And it's not written in the legislation. It's not written in any explanatory memorandum. All of those
that
things
would
have
be
to go.
evidence. That would be evidence entered at the case.
Yes, that's what I'm saying.
So
Yeah, no, but
quickly,
I'm saying that could be used as something for interpretation.
the government or the defendant would have to enter the Federalist Papers as
Yes,
the thing,
yes.
and they
Actually, yeah, you make a good point. They'd have to enter it as evidence. From a procedural point, you're right. They should absolutely be entering it.
and the other
But that's
thing.
not what Scalia does.
There is one other thing that they have to take into thing. Uh, things that have been found, facts that have been found by a jury of a lower court have to be considered. They're the only things that have to come into consideration for it. So
Okay. Tim, do you have anything to add?
I've mainly just been using this as a, listening to you and offering my own opinion. So yeah, that was a good discussion.
Yeah.
so
Okay.
are we? Um,
I
so
think well, it's gone on for more than 30
yeah,
minutes. I don't know if you want to keep talking, but like I think we've covered all the major points.
yeah. I was just gonna say we're
Uh,
all happy Scalia's things when he was an originalist. He could go quite further away from things than when he made much more textualist decisions.
yeah,
And
I
prism is a more predictable, um, method of getting a reasonable outcome for the law, though not necessarily producing the best outcomes all the time.
I will make this final thought is that I disagree that originalists, um, can never be disproven.
okay. How would you say that they'd be disproven?
Well, I believe that you can pinpoint that what the founders or did originally intend.
I think
How,
you
what,
I think you could contradict a certain opinion, like if they said,
Well, I
"Well,
know. Well, I don't concede that. Sorry, I'm happy to concede that
yeah,
point, but that doesn't necessarily disprove their position. I mean, it's like if you talk to an originalist and show them the contradiction, would they drop their opinion immediately?
So you're saying that whatever they're already biased, you're saying the originalists, and so they'll find whatever they want to find.
Yeah, pretty much, because that's what Scalia did, and
Yeah.
like he did
Well,
that several
it was
times.
still it was still there the what the founders said, so he didn't pull it out of thin air.
As long as you can find some contextual evidence that shows that a founder had some intent, sorry, has verbalized or sorry has um, authored their intent for that piece of law somewhere, right? I think an originalist would pick whichever one is convenient for their interpretation and stick with it. The reality is we all make contradictions every day. We contradict ourselves several times.
mm,
It would not be unheard of to see contradictions in the opinions of the founding fathers. What I'm saying is I don't think someone like Scalia or any other originalist would have allowed that piece of contradictory evidence to necessarily change their ruling, which is why I side with Dom on this in saying that textualism is probably a better way to go.
Well, perhaps that's just with some originalist then. Anyway, we're not going to solve it tonight.
No, we're not going to solve it tonight. But like, I hope everybody who's been listening to this didn't just get bored out of their minds, because we did get. I hope we got like technical to the point where lawyers are sitting there and like tearing their hair out and going, "Yes, that's the right word, but you're using it the wrong way," or "Yes, you've said the right thing, but you've missed this." And I'm hoping that we get plenty of comments like that. But I know that this is a very dry topic, which is why I left it off the main show. Hopefully we'll do more of these kind of things, and hopefully we'll get some other panelists as well in, possibly some experts, so that we can actually be guided a little bit in discussion. But for our first attempt this year, I think we did well. And I'm going to call it at that. So I hope everybody enjoyed. Bye.
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 Can you end it, Lee?
I know that Tom Woods and his historian colleagues Kevin Goodman and Brian McClanahan, they try to address the contradictions in the Founding Fathers as much as possible to, prove that, they were libertarians.
Well, I think that
They probably were.
from where we were,
Yeah.
but in terms of some of the stuff that, like, implementing tax on whiskey, the tariff things, some of the very Alien and Sedition Act passed in 1797. That sort of tyranny came creeping back very quickly. Just the founding.
Yeah, I was going to say they used to fight economic trade wars. So, like, for example, there was a time, you might not know this, but like there was a time when the US subsidized its industries, particularly textiles, to try and basically to try and overcome British tariffs on textiles coming from the United States.
And then it tried to have the other thing going back around when the Japanese started making steel so incredibly cheap. And US were instrumental in getting the worldwide anti-dumping regulations put in, which have been one of the worst things for free trade since free trade agreements. So,
Anyway, I think your knowledge on the Founding Fathers is greater than mine, so I'll leave it at that.
Anyway, all right, next week we'll do another episode, but thanks for everyone for coming. By the way, I was actually going to say next week is going to be my last episode for like 2 weeks, because I'm going to be in the
Is
States.
this one you?
Yeah,
Cool.
yeah. I was going to
So
say,
let's,
sorry, what?
Oh, you go.
Yeah, so what I was going to say is, Lee, we might consider, I don't know if you'll be up at the time though, but maybe we can do something where I can like record a couple of videos from CPAC. Is it possible? If you're awake.
Maybe. Yeah.
Maybe, but his microphone is muted.
Maybe.
Maybe. We'll see if we can find out the time. So what is the time according to you in Washington, D.C.? Sorry, no, what is the time now for you?
So I'm basically lined up with the East Coast. So it's 12 hours behind.
Really?
Yeah.
So you're telling me that it is 5:52 p.m. over there right now?
6:52.
So,
It's
yeah.
6:52 p.m. for me right here. I don't know what they are.
5:52 a.m.
Okay, so it's like what, 13
So-
hours?
13 hours, yeah. So add 1 hour. That is terrible for timing.
Well, not really. It means if you're doing it at 7 o'clock at night, I'm up at 8 in the morning.
Ah, yeah, that's true. Yeah, so we'll have to do our stuff at night. That's fine. Cool. I might record some shit then. We'll talk a little bit later then
Alright,
about that.
okay.
Okay. Cool.
see you guys.
Alright, see ya.
See ya.